We have a statement that the attorneys who are representing Theodore Edgecombe submitted saying, quote, attorneys for Mr. Edgecombe maintain that unlawful possession of a firearm does not preclude him from acting in self-defense. Mr. Edgecombe decided to make that a non-issue by accepting responsibility for the bail jumping charges. He maintains his actions were in self-defense and looks forward to establishing the same at trial. Boy, that sounds like a hint that he's going to take the stand. Let me bring in our guest on the program, criminal defense attorney John Mobley. He practices in Columbia, South Carolina. John, what do you think? Do you think Theodore Edgecombe's going to testify?
I think he will. I think his chances of getting an acquittal increase dramatically because he can say things about his observations that the state may not be able to contradict. There are a lot of different cameras, as we've heard, from different angles, but the lighting's not great. He can make a substantial number of statements regarding what he perceived, what the attorney said to him during the attack, and the state will not be able to really provide any evidence to the contrary. Of course, you can expect that the gentleman's wife is going to have a different version, but that's not going to be a surprise if she says something different. But even she has to admit that it was dark, and so I think he's going to do that. And I think that it really, if he just makes some reference to believing the guy had a knife or indicating the person said he had a knife and was going to cut him, the state really can't do anything or prove anything to contradict him because he did have a knife on him. And, there's a saying, you can't bring a gun to a fist fight, but it's okay to bring a gun to a knife fight because you have, some indicators of deadly force being used against you. So I think that's a strong likelihood.